Torah ethics calls for the abolition of the death penalty in the United States. So I'm going to ask you to raise your hands, and you're going to have three different ways to vote: agree, disagree, and unsure. And at the end, we're going to look not so much how many people voted for what, but how many people changed their opinion. So all those who believe, yes, that Torah ethics does call for the abolition of death penalty in the U.S., please raise up your hands. We're going to count the amount of people. Now, we're going to do the second vote. Who says negative, that Torah ethics does not call? Who says negative? How many people do we have for that? And finally, this is how many is unsure. So we're going to ask for the two rabbis first to make a presentation to give the sense of background. Then we're going to hear 2 points of view from the law professors. So first I'd like to call Rabbi Shlomo Yaffe, who is the Dean of the Institute of American and Talmudic Law. Many of us heard him throughout the retreat, to present his background information. Rabbi Shlomo Yaffe.
We have here 10 sources or ideas that exist in Jewish law. And again, I am speaking exclusively from the perspective of the Torah's law itself, hermetically sealed, which means to say we're not bringing in the practicalities of American society, anything like that. That is what our esteemed panelists will do. One, there are clear psukim in the Torah, clear verses in the Torah, and rabbinic sources that interpret them that call for the death penalty in cases of murder. Like we see, for example, in Shemot Chaf Aleph, one who strikes and kills another shall surely put to death. The Torah rejects the argument of why have another life lost? It won't bring back the victim. This is a phrase that's also quoted by Rashi, which means to say every Jewish child who's had a decent Jewish education has learned this. It says, lest you say, given that the victim is already dead, why should we take the blood of another? It's therefore written, let your eye not pity him. 3, you might argue that this is only for Jews. It's only in the laws of the Torah that apply to Jews. But the truth is that the Noahide laws, the universal law for all humanity that God gave to Adam, restated to Noah, and commanded to Moses to tell the Jewish people that it's their job to teach it to the whole world and to get the whole world to follow it. It says as follows. We see from Maimonides, codifying what it says in the Talmud. How must Gentiles fulfill the commandment to establish laws and courts? They're obliged to set up judges and magistrates in every major city to render judgment concerning these 6 mitzvot. And earlier he writes, a Gentile who slays a person should be executed. So it's not just Jews who get executed for murder, but also Gentiles. It's universal from the perspective of Judaism itself. Number 4, so the rationales that exist that are quoted in various Jewish sources, which means to say between things stated explicitly in the Torah to rabbinic commentary to this day, are the following: deterrence, to eliminate evil; kapara, which means to say atonement, that in a sense when you've done something so evil, you need atonement, and the wrenching and horrifying experience of losing your life for your crime represents a degree of expiation, a degree of atonement that balances the horrifying experience you inflicted on the other person, and it provides atonement. And last of all, the killer's mission in life is over. In other words, the idea is that the reason why once you've committed a murder, you have so degraded your spiritual status that there's nothing left valuable that you can do. This sounds counterintuitive, but it means to say that your existence is detrimental. And on this concept, it's worthwhile to think about the idea that if a society, again, this is the Torah's argument, it's nothing, but the Torah is basically saying that if a society allows someone who has contempt for human life, for the image of God that exists in each one of us to exist, if you allow there to exist on this planet someone who has contempt for the very value and divine value of humanity, this means the whole planet doesn't respect life and the value of humanity, because you're letting someone who denies the most fundamental thing that God wanted, that each of us should exist for as long as God wants that person to exist. This person believes they are God and has contempt for the image of God. There's no greater idolatry than murder. So to allow such a person to exist, it distorts the very fabric of existence. As Maimonides puts it, there is nothing which distorts civilization more than this. Okay, and I'm now going to give it over to Rabbi Dinnerman.
Okay, thank you very much. I'm going to continue what Rabbi Yaffe was doing. He spoke more in the abstract and about the theological points. I'm going to move a little more to the concrete, but just like Rabbi Yaffe, I'm going to be talking in a vacuum, meaning I'm going to be talking about, when we open up books of Jewish law, talking about how Jewish law would legislate these things, how that would look. I am not having any discussion as to whether and to what degree that has any relevance to how the American government or our American society should adhere to these teachings, if at all, and if yes, to what level. So we'll continue. So number one, the first important point, number 5, is that we cross-examine witnesses in the courtroom in Jewish law in order to make sure that we're not getting false testimony. And there's actually a very stern warning that the judges would tell witnesses in a capital case. And I want to read from it because it's quite powerful, and this is what the Mishnah says. In a capital case, we bring the witness in and press them. Perhaps what you say isn't eyewitness testimony, but your own conclusion or hearsay. Or maybe you saw a different witness testify about this. Or you heard this from someone trustworthy. Or perhaps you were unaware that we would interrogate you with examination and inquiry. In other words, the judges are offering this witness a ladder down in case the testimony was false, giving him an exit hatch to say, oh, yes, maybe it was. They continue, know that capital cases are not like monetary cases. In monetary cases, a false witness can return the money and achieve atonement. But in capital cases, the blood of the victim and all his future offsprings hang upon you until the end of time. Thus we find with regard to Cain, who killed his brother, where it says, the bloods, note the plural, of your brothers scream out. The verse does not say blood, but bloods, because it should say Cain was responsible for his blood, meaning Abel's blood, and also the blood of his future offsprings. When we kill one person, it's not just one person. It's the person's future, which includes the progeny. It was for this reason that Adam was first created alone, to teach you that anyone who destroys a life is considered by Scripture to have destroyed an entire world. And anyone who saves a life is considered to have saved an entire world. So this is a very important message that the judges impress upon the witnesses before they accept their testimony. Number 6, the death penalty in Jewish law only applies when we know for sure there was complete malicious intent. Therefore, we have a law requiring that 2 witnesses offer a warning. You're not allowed to do that, and if you do that, you're going to suffer the following consequences. The person needs to hear the warning and not just nod his head or say yes. The person has to say, yes, I recognize that, and I'm doing this nonetheless. As you read it here in the source, the witnesses must warn him and say, desist, do not do it. It is a transgression. You are liable to be executed. If he remains silent or nods his head, he is not liable for punishment because he has a defense that he didn't really know or didn't really understand. Even if he says, I know, he is not liable until he accepts death upon himself, saying, it is for this reason I am doing this. Next paragraph. But he must commit the transgression directly after receiving the warning, within the time to offer a salutation. If he waits longer than that, a second warning is necessary. So in other words, what needs to happen is the warning, acceptance of the warning, and the commission of the crime within a span of about 3 seconds. Once that time elapses, we're back to no ability to use the death penalty. Number 7, many laws are geared to make sure we have the right person. So circumstantial evidence is not allowed in a court of law. There must be 2 witnesses, and they cannot be related, and there are many other regulations about these witnesses. And we do not accept confession, even if it's offered voluntarily, but I'm not going to read the text. You'll trust me that confessions are not allowed as legislated here by Maimonides based on the Torah. Oh, no, this text actually here is important because it negates the circumstantial evidence. You'll see how drastic this gets. We are forbidden from punishing someone on circumstantial evidence, even if his guilt is virtually certain. An example of this is a person who was chasing after his enemy to kill him. The pursued escaped into a house, and the pursuer entered the house after him. We enter, meaning we the witnesses, enter the house after them and find the victim lying murdered with the pursuer standing over him holding a knife, and both are covered with blood. The Sanhedrin may not inflict the death penalty on this pursuer since there were no witnesses who actually saw the murder. This is a very, some might say, bizarre ruling, and we're going to come to some sort of rationale in a moment, but that's how strong this rule is of negating the admissibility of circumstantial evidence into the courtroom in these areas. That's the confession law that I'm going to skip. 2 more points. Number 1, procedurally, the court does everything it can to spare the suspect. So, we try to find any type of merit, and there is no limit to the number of appeals. Acquittal is allowed by a bare majority, but conviction requires the margin of 2 judges. Okay, so we'll read that inside. Here's the law as codified by Maimonides. When one of the scholars says, so the way the Sanhedrin works is you had the judges, and then you had people in the gallery. What happens if someone in the gallery says, hey, I can suggest a rationale that would convict this person? We say, be quiet. But what if the person says, I can teach a rationale which will exonerate him? We say, come, you're going to join the court. Okay? Here's the court doing everything possible to try to allow this person to go to avoid the death penalty. Even if the defendant himself says, I can exonerate myself, we hear his statement and he is counted among the judges. He becomes part of the number. So if we're talking about a Sanhedrin of 23, he becomes one of the 23, provided his words are of substance, obviously. In the case of error, if there was an error that exonerated, too bad. If there was yes, we never look back and say, oh, well, new evidence emerged. No, if once the court exonerated him, there's no double jeopardy, the person's finished. No, we don't. If, however, on the other hand, there is evidence that emerges later to exonerate the person, then we will overturn an earlier conviction. And then the following law here on the bottom of the screen is where Maimonides says you need to have not just a slim majority, but a majority of 2 judges in order to convict, whereas to exonerate you only need 1 in the majority. Might innocent people be able to walk away under these rules? Perhaps, but this is what Maimonides says. He says like this: if the Torah allowed the court to punish when the offense was very probable, even almost definite, they would carry out punishments in cases which were less and less probable, right? How do you draw the line? Until people would be constantly executed based on flimsy estimation and judges' imagination. God therefore closed the door to this possibility and forbade any punishment unless there are witnesses who are certain beyond a doubt that the event transpired. And here he says a very famous phrase: it is preferable and more proper that even 1,000 guilty people be set free than to execute even 1 innocent person. Finally, part of this, I think, and here we'll move to a second theology, is that Judaism does believe that the ultimate judge is God. He invites us to partake in the practice. But then there are times he says, hold off, your job is done, I'm going to take care of the rest. We don't believe that the court, the human court, is the final arbiter of justice. We believe that the human courts implement a small measure of justice, and God wants us to do so, but ultimately God is the ultimate judge who will dispense justice in the ways he sees fit. As the verse says, for judgment belongs to God. So with that, I hope that what Rabbi Yaffe said and what I said gave you a somewhat of an introduction to how these concepts are treated in Jewish law. I'm very curious to hear how these sources and perhaps others are going to be applied to the question of the death penalty in the American judicial system.
Now, arguing for the motion, Torah ethics calls for the abolition of the death penalty in the United States, Professor Pritikin.
Thank you, everyone. Hi, I'm Marty Pritikin, Dean of Concord Law School. I wanted to thank JLI for inviting me here today. I want to assure you all who've seen the promotional poster for this event, I'm not as mean as my picture. And I also want to clarify that what I'm talking about here is not whether I like the death penalty, whether I think the death penalty is a good idea in general, right? But whether I think Torah ethics would call for the abolition of the death penalty in America today. And I think clearly they would. If you listen to the points that Rabbi Dinnerman talked about and the limitations that the Torah, as interpreted by the sages, if you look at those limitations, we see that the American death penalty violates every one of those things. First of all, he talked about evidence of intent. There has to be a warning, two witnesses, verbal acknowledgement of the warning immediately before committing the act. All those things are required before the death penalty can be carried out. And of course, we have none of those things in America. There's no requirement that there be two witnesses or even one witness. There's no requirement of a warning immediately before the act. Of course, because we know most people, when they commit killings, they try and do so in secret. There's certainly no requirement that they acknowledge verbally a warning immediately before acting. And so we don't have that assurance that the killer is calmly, rationally deciding to transgress the law and willingly take a life, knowing exactly what the consequences will be. That's number one. Number two, Rabbi Dinnerman talked about how there are numerous features, evidentiary and procedural limitations to ensure that we know we have the right person. For example, we don't allow circumstantial evidence. We don't allow confessions, no matter how voluntary. Well, of course, in the American criminal justice system, not only do we allow circumstantial evidence, but in part because there are rarely eyewitnesses, we often have people who are convicted entirely on the basis of circumstantial evidence. And although in our system a defendant has a criminal constitutional right not to testify on his own behalf if he doesn't want to, we know that pretrial confessions are routinely admitted in criminal cases. And if you heard the panel yesterday talking about false confessions, right, we heard somewhat about that. And we know that often those confessions are obtained under circumstances where it's not at all clear that they were in fact voluntary, even if they claim to be. Now, even where a conviction is based on witness testimony, psychologists, social scientists, researchers have shown time and time again that witness testimony can be unreliable, particularly in the case of cross-racial identification. And unlike in the Torah system, where we scrutinize the witnesses and really try and impress upon them the significance of testifying falsely, try and give them any out so they don't testify against the defendant, we don't have such a system in our American criminal justice system. Yes, witnesses take an oath to tell the truth under penalty of perjury, but other than that, we don't scrutinize them on every little detail of their testimony. And Rabbi Dinnerman didn't talk about this, but some of the details that would be gone into in the Torah system would go to the exact time of day, the exact location. Do you remember what the person was wearing? Was the moon out? I mean, looking for little details to try and find ways to have the witnesses contradict each other. And in the American system, although defense counsel would be free to cross-examine a prosecution's witness about details, all of that would generally go to the weight of the testimony, how much the jurors should believe that witness, not whether that testimony is admissible in the first place. Now, Rabbi Dinnerman cited the source that said that better that 1,000 guilty people go free than one innocent person be executed. Well, we know that that is not the case in the American system. Studies have shown that since capital punishment was reinstated in America in 1976 after a brief hiatus based on the Supreme Court, at least 138 people who were sentenced to death were exonerated. At least 138 people. The number's probably a little bit higher now. And if you actually look at the number of people who've been executed in comparison to the number of innocents who've been exonerated, it's a ratio not of about 1 to 1,000, but about 1 to 10. So I think that data clearly shows that Torah ethics would not be comfortable with the death penalty being carried out in America today. Now, of course, one practical consideration that isn't addressed in the Torah sources is the cost of inflicting the death penalty. As it turns out, because there are so many appeals and so many procedural safeguards that go into capital cases in America, it actually costs more to sentence someone to death than it does to put them in prison for the rest of their life without possibility of parole. Now, again, cost is not a big argument from my perspective, but it should be noted that one of the main ways people talk about reducing the cost of imposing the death penalty is by reducing the number of appeals or reducing access to appeals. But, of course, if you do that, you potentially increase the risk of erroneous execution of an innocent. So it exacerbates that problem. The third thing that Rabbi Dinnerman talked about was how the court will take steps to try and find some reason to quit the defendant even after there's been initial conviction. They will allow any third party or the defendant themselves to raise any grounds to try and overturn the conviction. We don't really have that in our system. In fact, in the American system, capital cases are bifurcated, where first there's a guilt phase and then there's a penalty phase. And in the penalty phase, the prosecution is allowed to introduce evidence that wouldn't have been allowed in the guilt phase, like victim statements, right? Well, not the victim itself, they're dead, right? But relatives of the victim to talk about how painful and wrenching the loss of their loved one is. And that's something that's supposed to influence the jury in deciding whether to render a decision to inflict capital punishment. In addition, many criminal defendants are indigent. They don't have the money to afford their own counsel. And in general, the Constitution only requires that there be one level of appeal after the trial level. And after that, a defendant's on their own. And so even though there may be multiple appellate stages to go through, American criminal defendants don't often have access to counsel for that. And we know that very often once you get to the end of the road in a state-level appeal, the only option is habeas corpus proceedings in federal court. But the rules on habeas corpus were never that broad to begin with and have been restricted over time to make it harder and harder for even a meritorious habeas appeal to be successful. And this doesn't even get into the issues of ineffective assistance of counsel, right? We know that 68% of convictions that are overturned on the basis of ineffective assistance of counsel. This doesn't even get into the fact that the death penalty is applied inconsistently, not only from state to state, depending on the environment in the state. Texas, of course, is well known to execute far more people than most other states. Even from county to county, depending on the particular prosecution, the particular office of the prosecutor involved. And this, again, doesn't even get into the racial disparities that are well known in the American criminal justice system, with people being far more likely to be convicted if their victim is white as opposed to African American. Now, I've been talking about how the American criminal justice system doesn't live up to the requirements of Torah law as Rabbi Dinnerman described them, but I want to spend a few moments talking about how the rationales that Rabbi Yaffe talked about. He said that one of the primary rationales for the death penalty in Torah law is deterrence. However, the American criminal justice system, capital punishment, doesn't deter. Studies have shown that jurisdictions that don't have the death penalty tend to have lower murder rates than those that do. Unless you're Texas. If you're willing to execute as many people as Texas is, then it can have a deterrent effect. But short of that, it actually seems to have the opposite effect. Rabbi Yaffe also talked about the idea that executing the murderer can serve as a kapara, as an atonement, right? That we're actually concerned about the killer's soul. But of course, in the American criminal justice system, which is a secular system, that wouldn't even be an appropriate consideration to look at. And even aside from the mixing of state and religion, I think a lot of people in America would be offended by the idea that in deciding what punishment to carry out, we're actually concerned about the interests of the killer. In fact, there are some people who oppose the death penalty because they think death is too good for the person. They'd rather have them sit and rot in jail for the rest of their lives than get an easy out by having their life ended. So I've talked a lot about how I think the American criminal justice system doesn't live up to the ideals of the Torah. And I've been trying to talk about some of the practical impacts in terms of the risk of erroneous conviction and the cost and the inequities and the way it's applied. But we do have at least a little information about the practicalities of how the death penalty was carried out under the Torah system itself. There's a famous Mishnah in Masechet Makos. Famous means I know about it, but actually a lot of people have heard about it. There's a Mishnah that talks about what it means for a Sanhedrin, a high court, to be a bloody or murderous Sanhedrin, right? One that really inflicts a lot of vengeance. And the Tanna Kama, the initial author of this source, says that a bloody Sanhedrin is one that carried out an execution once every 7 years. Once every 7 years. Then, there's actually 4 opinions in this Mishnah. The second opinion, Rabbi Eliezrie ben Azariah, says that actually a bloody Sanhedrin is one that will even carry out an execution once every 70 years. 7-0. Then there's Rabbi Akiva and Rabbi Tarfon who say that if it was up to them, they would ensure that no one was ever executed. They would find contradictions between the testimony. They would do what needed to be done to ensure that no one was killed. Now, to be fair, there is a fourth opinion, Rabbi Shimon ben Gamliel, who says that if you followed Rabbi Akiva and Rabbi Tarfon's opinion and never executed anyone, they would cause murderers to multiply in the land of Israel because you would lack that deterrence. Killers would know that they could get away with it. But that is just one opinion. It is the minority opinion. And if you look overall at the balance of Torah law, as a practical matter, it appears that although, on the books at least, capital punishment was authorized, it was very rarely inflicted. And if we look at the way the capital punishment system works in America today, it is inconsistent with the rationales for the death penalty in Torah law. It is inconsistent with the evidentiary requirements. It is inconsistent with the procedural requirements. And therefore, I think it is clear that the motion should pass because Torah ethics would call for the abolition of the death penalty in America today.
Thank you very much for that very interesting and articulate presentation. Arguing from the second side, from the other side, that Torah ethics doesn't call for the abolition of the death penalty is Professor Levine from New York.
Thank you very much.
You notice the guy from California is against, the one from New York. What can I tell you?
Sounds good. And first of all, I also want to thank... Mic is working? Great. I also want to thank you for inviting me to participate in the conference. It's terrific to be here. And I really enjoyed Professor Pritikin's presentation. I'd like to respond based on the premise that the American legal system would not, if we applied the principles of Jewish law, if we applied the ethical principles, the rationales of Jewish law, we would not look to abolish capital punishment in the United States for a few basic reasons. So first, if we look at the rationales for punishment in the American legal system, the justifications for punishment, why do we punish criminals? On what basis do we have the authority and the right to punish criminals? The American legal system is broadly premised on 2 basic ideas. One is deterrence. The second is retribution. And taking them with retribution first, the basic idea, as a matter of justice, someone who commits a crime deserves to be punished. This isn't revenge. This isn't meting out revenge on someone or taking revenge on them. It's the basic idea that they have their just deserts. They deserve to be punished. Justice requires that if someone commits the crime, they do the time. If someone commits the ultimate crime of murder, they should have their life taken away from them as well. A principle in the American legal system of deterrence looks to the need for criminal punishment to prevent criminals from committing crimes. And when we talk about deterrence, we talk about both what's called specific deterrence. This particular criminal will not commit this crime again. If this particular criminal is imprisoned for their crime, that will prevent them from committing crimes while they're in prison. If a murderer is executed, they will be prevented from repeating another murder in the future. Likewise, general deterrence, the idea that as a general matter, the public at large, individuals who are in the process of formulating the idea to commit a crime, in the process of actually committing a crime, and deciding, making that split decision whether to go through with the murder, they will be deterred from actually carrying out the murder if they realize, if they are warned, if they're on notice, that if they go through with this killing, they themselves will be subject to execution. So the American legal system is premised on these 2 notions of retribution and deterrence. Well, likewise, as some of the sources that were quoted just before indicate, Jewish law looks to criminal punishment, and in particular, executions, the death penalty, as a form of both retribution and deterrence. The verses in the text of the Torah teach us, and this goes way back, as the Rabbi mentioned, to the Noahide laws, and the verses that state that if someone kills someone else, their life should likewise be taken. This is a universal principle. This is part of the Noahide universal code of law within the Jewish legal system. The idea that someone who commits a crime as a matter of retribution, as a matter of what we call deserts, not dessert like the cake, deserts with one S, that they deserve to be punished because they committed a crime, they committed a murder, they deserve to be killed themselves. Likewise, as the Rabbi mentioned, the text of the Torah warns us, instructs not to pity the murderer. And as the Talmudic teaching that the Rabbi quoted explains, there's a tendency, and we understand the notion of mercy. We understand the idea that, well, one life was taken, what good does it do now to take the life of someone else? And the Torah warns against this idea. As noble as it may seem, as idealistic as it may seem, well, the person who should be pitied is the person who had their life taken away, the victim, not the murderer. Likewise, in the American legal system, the notion of retribution, that the individual who committed the crime deserved not to be pitied, not to be subject to mercy, but to be subject to criminal punishment. And finally, within the Jewish legal system, although confessions, you're absolutely right, are not part of the criminal process, a criminal defendant in Jewish law is not permitted to confess to a crime. Their statements cannot be used against them in a court of law. They would be excluded from evidence. On the other hand, as part of the Jewish legal process, once a defendant has been duly rendered guilty and is going to be executed for a capital crime, before they are executed, they are encouraged, they are told that they should confess to their crime. Not because that confession is going to be used against them. The conviction had to be obtained in all the appropriate ways without using their own statements against them, but for the purpose of repentance. Jewish law considers part of the retribution process to involve a form of repentance, of absolution for the crime that requires the individual to confess to their sins before they are executed. So retribution is a very strong part of Jewish law. What about deterrence? Well, likewise, in the text of the Torah, we are told, and one of the sources the Rabbi quoted, to eradicate evil from our midst. We have to deter the individual who has committed a murder, prevent them from committing another murder by eradicating them from our midst. Likewise, in the American legal system, one of the functions of capital punishment is specific deterrence, to make sure that this individual does not go ahead and commit another murder. The notion of general deterrence, well, the text of the Torah likewise states that the nation should hear what happened, they should see what happens to the murderer, and they should learn from that. They should fear the punishment that's been meted out against this individual. In the American legal system, one of the functions of capital punishment, and the studies can go both ways. We don't really have categorical answers to the question of whether capital punishment deters one way or another. And without getting into the science of it, we don't have a control system. We don't know what would have happened otherwise. Would there have been more or fewer murders had we not executed certain murderers in a particular jurisdiction? So clearly from the text of the Torah, and clearly in terms of the function of our legal system, we do accept the notion that criminal punishment deters criminals from committing crimes. That if it's on the books, if there's a chance that the individual will be executed if they carry out this murder, that will plant the seed of doubt in the back of their mind, and hopefully it will come to fruition, that when they're making that decision whether to carry out this murder or not, whether to go through with this harshest of all crimes, they will be deterred because they don't want to face the harshest of all punishments. What about other Jewish sources? So as Professor Pritikin quoted absolutely accurately, the Mishnah does have a number of different views on capital punishment within the Jewish legal system. But I'd like to argue that if we look at this Mishnah as a whole, if we look at the different views in this Mishnah, it actually favors capital punishment on the whole. First of all, most of the views in the Mishnah do favor capital punishment. Even the view that says that one execution in 7 years is a lot is not arguing to abolish capital punishment. That would not support the motion to abolish capital punishment in the United States. It might support the notion. It might support the idea of reducing the number of executions, but it's not against capital punishment as a whole. Even the argument that once in 70 years is a lot of executions does not argue in favor of abolition. It's only the view of Rabbi Akiva and Rabbi Tarfon that apparently seems to favor abolishing capital punishment altogether. And of course, the fourth view that Professor Pritikin correctly noted, Rabbi Shimon ben Gamliel was concerned about the approach that would limit or abolish capital punishment because Rabbi Shimon ben Gamliel argued in favor of deterrence. He was concerned, and that statement he makes, that if you abolish capital punishment, you will increase the number of murderers among Israel. Likewise, in the American legal system, if we abolish capital punishment altogether, the Jewish legal system, the Jewish approach, Jewish ethics would be concerned that that would actually increase the number of murderers in the United States. I'd also like to argue that even if we consider these numbers, the 1 in 7, 1 in 70, we have to think carefully about the context of this statement. So first, these rabbis seem to be talking about one individual court, a court that executes one individual in 7 years or 70 years. Well, there was more than one court in ancient Israel. There were numerous courts. So if one court executed one defendant, one criminal, one murderer in 7 years, well, other courts might have done the same, and the numbers might be higher. I think it's also important to think about the context, the population, the type of society that we're talking about. The number of people, the population in ancient Israel when these statements were made was probably somewhere in the neighborhood of 2.5 million to 3 million people. In the United States today, we have about 300 million people. So if we do the math a little bit and we talk about proportions, well, 1 in 7 years would have to be reduced by a factor of probably 100, right? 3 million instead of 300 million. So if we think about these statements in the context of the number of populations that we have now in the American society and the type of society that we're dealing with, the Israeli, ancient Israel, was a largely agrarian society, probably did not have the same numbers, the same incidence of violence and certainly of murder that we have in contemporary United States. So even if in their situation they would argue that 1 in 7 or even 1 in 70 executions is a lot of executions, well, if we apply that to the vast numbers and the vast numbers of murders that take place in the American legal system, I think the argument would be in favor of maintaining capital punishment within the American legal system. And again, as I mentioned, clearly the fourth position in that Mishnah, Rabbi Shimon ben Gamliel, argues in favor of deterrence. His view would not favor the motion, would not militate abolishing capital punishment within the American legal system. So in short, I would say whether we're talking about restitution or deterrence, the sources in both the written text of the Torah and the sources in the oral tradition in the Mishnah would actually not favor the motion, would actually lead us to the conclusion that we should not abolish capital punishment in the United States. I'd like to make one final point. Responding to the very important observations Professor Pritikin made and the rabbis presented regarding the procedural safeguards within the Jewish legal system. And procedural safeguards are all important in the American legal system. We try our best. No system's perfect. There are miscarriages of justice within the United States. We do have our procedural safeguards. We do make every effort within the American legal system not to execute an innocent individual. The Innocence Projects that Professor Pritikin rightly cited have exonerated individuals on death row, have resulted in an additional safeguard in our own system to prevent innocent individuals from being executed. But within the Jewish legal system itself, as much as this system is concerned and deeply concerned with making sure that individuals who are innocent are not wrongfully executed, and all those procedural safeguards that you detailed regarding the two witnesses, regarding the necessity that the defendant actually accept the warnings and accept the fact that they're going to be executed for their crime. Well, the Jewish legal system also has alternative methods of maintaining law and order. And all of those procedural safeguards that are noted, as important as they are, they represent a form of idealistic justice, a form of divine justice. And God is perfect, but we are human beings who have to implement the administration of justice, who have to implement the legal system. And within the Jewish legal system, there's a recognition that in addition to and beyond that ideal form of justice, there's the practicalities of having to maintain law and order within society, having to punish and deter criminals, and therefore Jewish legal authorities have discussed whether it's the king who serves as the executive branch, whether it's the court that later served that function, there is the authority of the executive branch to step in. There is the authority of alternative branches of government to step in and to execute individuals who are not subject to capital punishment under the general administration of justice, who are not subject to capital punishment because of those procedural safeguards. And that very important part of the system, that aspect of the Jewish legal system that incorporates law and order, that incorporates punishing criminals who otherwise might escape punishment based on loopholes, might escape punishment based on technicalities, the Jewish legal system recognizes that society would not be able to function properly, that we must deter crime, that we must punish crime, and that requires, at times, when necessary, and this is cited in the Talmud, this is cited in Maimonides, when necessary, it's important for the executive to step in and execute murderers so that we can serve those dual functions. And again, in closing, likewise within the American legal system, the Jewish ethics would not support the notion and the motion of abolishing capital punishment. Thank you.
We're now going to ask each one of our points of view to give a 3-minute rebuttal. First, we're going to begin with Professor Pritikin, who is arguing for the motion.
So Sam's last point, I think, was a good one, and one that I think I need to respond to, because although the Torah system of judicial procedure and evidence makes it virtually impossible as a practical matter to actually convict someone and execute them, well, that raises the question, well, what's the point of having all those requirements if, a leader could just go and decide, yeah, I know that you weren't warned, or I know you didn't acknowledge the warning, but you're guilty, so let's go ahead and execute you. That's, I think, a potential problem for my position. I will admit that. And here's my response. My response is, look at who's vested with that authority. I'm going to cite to you from the Rambam, is one of the earliest codifications of Jewish law. He talks in his Law of Courts about the requirements of courts and judges. It says, we appoint to a Sanhedrin only people of wisdom and understanding, of unique distinction in their knowledge of the Torah, and who possess broad intellectual potential. They should resemble Moses in wisdom, in the fear of heaven, and in lineage. They are to appoint people who are mighty in their observance of mitzvahs, very demanding of themselves, and who overcome their evil inclination until they possess no unfavorable qualities. They should have a courageous heart to save an oppressed person from the one oppressing him. In terms of the procedure for doing this, the Supreme Sanhedrin would send out emissaries throughout the entire land of Israel to seek out judges, who would be appointed or promoted, not elected, on the basis of their being wise, sin-fearing, humble, modest, with a good reputation, and beloved by people at large. And it wasn't a popularity contest. In fact, it goes on to say, whenever a Sanhedrin, king, or other leader appoints a judge who is not fitting and or is not learned in the wisdom of Torah and is not suitable to be a judge, even if he's entirely a delight and possesses other positive qualities, they violate a negative commandment. And it's a positive commandment to adjudicate righteously. It goes on to say a judge should always see himself as if a sword is drawn on his neck and hell is open before him. He should know before whom he is judging and who will ultimately exact retribution from him if he deviates from the path of truth. And it's not just judges, it's other leaders, it's even kings. Rambam goes on to say that a king should be involved with Torah study and the needs of Israel by day and by night. But the Torah trumps, no pun intended, even the king's commands. And people are permitted to disregard and may not be punished for disregarding even a royal commandment that contravenes the Torah. So the point is this. When you have illustrious sages that the entire society has common views about who they trust and what value system they adopt, those are the people that you can entrust with the power of life and death. But that is not our system in America. We have juries. In fact, the Constitution requires that juries and not judges, regular people with no particular expertise, who frankly probably don't even want to be there, are deciding life and death. And I don't even know that we trust our judges or our quote-unquote kings. So because of this, because we don't have this cultural agreement, and because we don't have people who we trust with the power of life and death, even with extrajudicial killings, I would say that Torah ethics would call for the abolition of the death penalty.
Thank you very much, Professor Pritikin. And now Professor Levine for his response. Is your mic working?
My mic works. Okay. So just a very brief response to close. Again, the American legal system is not perfect. No legal system is perfect. God's divine system is perfect, but we're human beings and we're implementing our laws as best as we can. We need to deter punishment. We need to punish criminals on basis of both deterrence and retribution. The motion that you're going to be voting on is whether Jewish ethics require the abolition of capital punishment in the United States. There are problems. The system has to be, these problems have to be addressed. The system has to be remedied. But if the question is whether to abolish capital punishment in the United States, well, the sources in Jewish law, as concerned as we are about the potential of wrongful execution, the sources in Jewish law remind us that those basic principles of deterrence and retribution require that wrongfully committed wrongful actions be properly punished. And likewise, in the United States, we should not abolish capital punishment.
Thank you very much. I want to thank both of our points of view who argued in such a beautiful and articulate fashion. What we're going to ask now is for you, the jury, the non-expert jury, which is very interesting. One of the points is about in Judaism there is expert judges, and in American legal system we have, let's say, very well-informed, intelligent members of the jury, to vote again. And we're going to see, our interesting question that we're intrigued with is how many minds were changed. So first, again, the motion is Torah ethics calls for the abolition of the death penalty in the United States. Who agrees with this premise, please raise your hand. Okay, we got the count. And again, now we're going to say the same thing. Torah ethics calls for the abolition of the death penalty in the United States. Who disagrees with this, please raise their hand.
Keep your hands up.
Keep your hands up. And finally, there's always Jews who are unsure. Those who are unsure of either point of view, please raise your hands. So the side that changed the most was the agree that went from 16 to 34, the disagree went from 32 to 35, and the unsure went from 25 to 8. So we see the motion then is supported is a motion of Torah ethics calls for the abolition of the death penalty in the United States. I want to thank everybody. I want to just throw something in to change, just as, so to speak, an after-the-fact argument that none of the professors mentioned, which there is an opinion in Jewish law, there's an opinion in Jewish tradition that Jewish law is really not important. Because according to Jewish law, the laws of Noah apply for a country like the United States. And as long as you have court system which has built-in human rights protections, etc., then that court system could decide to make a death penalty with a different rules of evidence when Jewish law rules of evidence. There's a whole other perspective. It's just, so to speak, to stir the pot after the fact a little bit, the prerogative. But, you know, what can I tell you? I think it's interesting to think about that also. Thank you very much. It's been a very wonderful and intriguing session.
Thanks for watching. Click subscribe and hit the notification bell below for daily pearls of Jewish wisdom.